Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning. You are Monique Patterson?
Yes.
Ms. Patterson, your case is scheduled at 11 o'clock. You can either wait in the waiting room or come back. Which would you prefer?
Oh, okay. I'll leave and come back. It said 10 o'clock.
Oh, ma'am, it's 11 o'clock.
Okay, thank you.
Yes, ma'am.
Bye-bye.
We'll see you then.
Okay.
I don't know who these people are. Mr. Sparks,
Good morning, Your Honor.
why are you here today?
I am here for LVNV funding versus Powell.
Okay. I don't seem to see Ms. Powell as of yet. Sparks. So off to the waiting room you go.
That's fine. Thank you very much.
Maybe this is her here. Let's see if this is her here. Hello?
Yes,
What is your name?
Tanya Powell.
Okay, so we have both sides, Mr. Sparks. Let's get started.
Thank you very much, Your Honor.
We are on the record, calling file number 2116965, LVNV funding versus Tanya Powell. Date and time for a motion for summary disposition. Your appearances.
Keith Sparks here on behalf of LVNV funding, Your Honor, P77485.
And what is your name, ma'am?
My name is Tanya Powell.
Ms. Powell, did you file an answer to this motion for summary disposition?
No.
Okay, Mr. Sparks, you may proceed.
Thank you, Your Honor. This is a motion for summary disposition pursuant to MCR 2.116 C9 and 10. It's for a Credit One bank card that was opened back in April of 2018. Last payment was made in June of 2019. The charge-off balance was for $815.95, the same amount that we prayed for in the complaint. Attached to our motion are the chain of title showing ownership of the account by the plaintiff, as well as statements of the account which show purchases and payments to Ms. Powell. And so we would rely on the pleadings for all other matters and just request judgment in this.
Ms. Powell, you did not file an answer. Was there something you want to tell the court?
I didn't know I had to file answer. However, I did not make my last payment was in 2018,
Okay.
not 2019.
Okay.
I went into a hospital in August, and then I went to rehab. I lost my job due to MS, and I went on disability. I got my disability started in they approved me for disability as of August, but I didn't get the disability until April of 2019.
Okay. The court's prepared to rule in this matter. This is a motion for summary disposition under MCR 2.116C9 and C10. This motion was filed on or about April 25th of 2022, and it appears that the court sent notice of today's hearing on June 13th, 2022, setting the matter for hearing today, July 11th. No answer having been filed on behalf of the defendant. The court is going to decide this motion under MCR 2.116C10 because there are matters provided, appended to the motion beyond the mere pleadings. Under MCR 2.116C10, once a motion has been filed under that rule, the court rule is quite specific. A motion under subrule C10 must specifically, and I'm reading from MCR 2.116G4. A motion under subrule C10 must specifically identify the issues as to which the moving party believes there is no genuine issue as to any material fact. When a motion under subrule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavits or as otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. In this case, we have exhibits appended to the motion demonstrating the chain of title. We also have exhibits appended to the motion demonstrating the use of the credit card issued by the defendant and remaining balance. No responsive pleadings were filed on behalf of the defendant in this matter. The rule is quite clear. She may not rely upon previous pleadings, but must file a response and demonstrate that there is a genuine issue of material fact. Court finds there to be no genuine issue of material fact. Summary disposition is therefore granted in favor of the plaintiff under MCR 2.116C10. Counsel, I look forward to your judgment. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out to both of you a copy of the order of judgment as soon as it has been provided by counsel and entered by the court. Thank you both for coming in. We are off the record.
Thank you, Your Honor. Would you like me to file that under the 7-day rule or email it to your clerk?
7 day will be fine.
Thank you very much, Your Honor. Have a good day.
You too, sir. Morning, counsel.
Good morning.
I think I have this counsel for the other side. We should be able to get started.
Okay.
Good morning, counsel.
Good morning. How are you doing today?
Good. How about yourself?
I'm doing well.
Let's call our case. This is 22-178-360 Briggs Realty PLLC versus Christopher Kelly. Your respective appearances.
Good morning, Your Honor. Zachary True appearing on behalf of plaintiff P83966.
Good morning, Your Honor. Kyle Dupuy on behalf of Mr. Kelly, P72892.
Have you filed an appearance here, sir?
I filed an answer.
You filed an answer.
I did.
You did. Somehow we didn't pick that up. Okay. We'll make that change on our records. So, gentlemen, where are we on this file?
We have spoken a couple times. It doesn't seem like there is a resolution at the moment. So I think we just need to open discovery and set a date.
Well, the court opened written discovery here back on May 25th. And then apparently you gentlemen took it upon yourselves to adjourn the pretrial without court approval. So here we are. So no discovery's been done since that time?
No, Your Honor.
Okay, two things. Let's get our discovery going. And secondly, you can't adjourn my dates without my approval.
Yes, Your Honor. I think at the last hearing,
What were you saying, sir?
at the last hearing, which I believe was scheduled for 2 weeks ago, I had
Was our schedule.
faxed in a stip in order to adjourn it. I'm sorry that I wasn't there. I had a prior engagement.
Oh, that's not a problem, counsel. But what you did is you didn't show up.
Right.
I didn't dismiss the case or default because of that.
I appreciate that.
You can't just simply decide you're not showing up.
Yes, Judge.
That's the way this works. So I'm gonna give you guys another date. I want to get started on this written discovery. What is the amount in controversy here? Ballpark,
It's just shy of $3,000, Judge.
okay? You guys can't work it out? You can't work it out, so be it. Let's get you a date, and now, gentlemen, I want some discovery done the next time we're together on this file. It's August the 29th, at 10 o'clock. Does that work for both of you?
I'll be out of town. Excuse me. I'll be out of town, Your Honor, until September 8th. I'll be out of town. So anytime after September 8th.
When
is
are
good.
you leaving?
August 19th.
Okay, that's no problem. We'll move it up. We'll see you August 15th. Does that work for everybody?
That's fine, Judge. Is that also at 10 o'clock?
Yes, sir. All right, August 15th at 10 o'clock. Let's get our discovery going, gentlemen. Anything else we'd accomplish today?
No, Your Honor.
I think so.
All right, let's get going on file, gentlemen.
All right.
Thank you,
Thanks for
Judge.
coming in.
Thank you, Judge.
Good morning.
Good morning, Your Honor.
What file brings you here today, sir?
I am here on the ASP Care Plus from Marissa King, Your Honor.
You're representing the plaintiff?
No, Your Honor, the defendant, Liberty Mutual.
Oh, okay, then I seem to be one defendant short. I have someone here for, let's get him in here. You're at 968, correct?
I'm sorry, what was that, Your Honor?
All right, you gentlemen are here on ASPS Care Plus versus LM General Insurance,
Yes, Your Honor.
Yes, Your Honor.
and you're representing who, Mr. Haskevitz?
Good morning, Your Honor. Doug Harriskevich on behalf of the plaintiff, 458.
All right, you guys, let's call your case. We are on the record with 22-181-968 ASP Care Plus versus LM General Insurance. Date and time for pretrial. Gentlemen, your appearance.
Good morning, Your Honor. Doug Harriskevich on behalf of the plaintiff, P81458.
Okay.
Thank you, Your Honor. Saga Rathod appearing on behalf of defendant, Liberty Mutual, P79339.
All right. First question, did Liberty Mutual make the 2.302A disclosures? We were last together on June 6th, and that had not been done.
Yes, Your Honor. I've just taken over this file as of last week. So I was reviewing everything. I did see that we had gotten the disclosures. I did not see that any information was sent over to plaintiff.
So you have not complied with the court's direction. Is that what I hear you saying?
It is my understanding that that was not sent out. My apologies, Your Honor. I have just reviewed the file myself.
We have a problem here.
I apologize.
We have a problem here. I'm sort of old fashioned, and for some reason or other, I kind of think my orders are supposed to be followed. I know this is confusing in this day and time, but that's really my understanding.
Oh, certainly, I would agree, Your Honor.
Well, the problem that I have is that we ordered that the initial disclosures were to be made back at the time we set the first matter for pretrial. However, looking at the disclosures from the plaintiff, it appears you're claiming $29,000. That's beyond my subject matter jurisdiction. What's going on here, sir?
Your Honor, let me take a look at our disclosures. Is that amount including no fault and attorney fees?
I'm looking at your initial disclosures, 29,90746. And that would appear to be $19,000 and $19,200 of medical, balance is 12% interest and attorney fees.
Yep, so the amount actually in controversy is less than $25,000?
Is there an ongoing treatment?
No, Your Honor. Not this facility, to my knowledge.
All right. Well, counsel, I got a problem here. I really am now in a position where we're literally at a standstill because the defendant has failed to comply with the court's order. And I really don't know what to do here because I had previously ordered the defendant to make those disclosures, both sides to make those disclosures when I set the first pretrial. The first pretrial was had on, that's by my notice dated May 9th. First pretrial was held June the 6th. And at that time, the defendant had still not made those disclosures. And here we are again, now and again. Those disclosures have not been made. We're now 2 months after the court's order, sir.
Would you like me to respond, Your Honor?
I would urge you to do so, yes.
Yes, sir. So, Your Honor, I do apologize. As I noted, I have just taken over this file as of last week. And as I was reviewing it, I did notice that the defense counsel has not provided those initial disclosures. I have contacted my team to make sure to get those out the door immediately. At today's hearing, I had my intention is to request additional discovery because our client has indicated that they would like to seek a couple of depositions.
I'm really not interested in what your client wants. I'm interested in compliance with the court's order, which your client has failed to do since May. 2 months.
Understood, Your Honor. And that's why now that I'm taking over the file, I have my hands fully invested in what's going on. And I can tell you that from me, the now attorney handling it, that I will get those initial disclosures over to plaintiff's counsel immediately. That was something that I did speak with my team about just on Friday to confirm that we were working on those and getting those out. Because I agree with you, Your Honor. You requested that they be sent out. And as soon as...
Stop, time out. Disc jockeys do requests. Judges do orders.
Oh, I apologize.
I ordered in May, on May 9th, that they be done within 21 days. They should have been done, therefore, in compliance with the court order by the end of May. They weren't done. We met in June. They were to be done immediately. They were not done. You're not getting the concept here. You really are not. What we're doing here is this is your opportunity for you to persuade me not to default your client.
Yes, Your Honor. And my persuasion to you would be that with my apologies to the court, the order was not executed as you'd required. But now that I am overseeing this case, I fully have respect and intend to honor every order that the court issues, which is why with me now on the case, I will be making sure that that gets done as the court has ordered, if you would so allow. The court does have my apologies. As soon as I have taken over this file, that was something that I made sure was clear to everyone on my team working on this file.
So we've wasted 2 months here, counsel.
I do apologize, Your Honor. I'm not
Wasted 2
one.
months here.
Yeah.
All right, this is what we're going to do. I'm going to set this matter for Friday at 10 o'clock. Does that work for both of you?
Your Honor, that works for our office. I am not. I am actually going out of town on Friday, so me personally, I would not be available. If you would like to put it on a different day so that I can be here, so that it's not another attorney.
Let me make clear what I'm doing here. Either those disclosures are filed by Friday, or the case is defaulted.
Certainly, and I will ensure that those are.
Or somebody from your office is here.
Okay, as long as that's okay with you. I just didn't want to put another face in front of you who's not going to be, the one with their hands on the file. Since I am now the assigned attorney, I want to make sure that I'm fully, aware in front of you for any matters.
Reread the court rule on appearances. In a civil matter, an appearance by an attorney is an appearance by every attorney in that firm. Who the firm puts on Zoom calls is up to the firm.
Certainly.
Does that, counsel, does that Friday work for you?
Yes, Your Honor.
All right, we're going to adjourn this matter to July 15th at 10 o'clock. If those disclosures are not made, counsel, your defendant will be defaulted.
Understood, Your Honor.
Clear?
Yes, completely clear, Your Honor.
Friday, July 15th at 10 o'clock, gentlemen. We'll see you then.
Thank you, Your Honor.
One
Thank
way
you,
to
Your Honor.
come. We're off the record. Explain the situation. How goes that? Oh, we are on the record calling file 21173-472, Beaumont Health versus Antonio Kelly. We were last together on this file on June 13th, 2022. At that time, the parties both agreed, along with the court, for a pretrial to be set out today July 11th at 10 o'clock. Notice of that pretrial was sent to both parties on that June 13th day. It's now after 10:30. Neither party has appeared. The case will be dismissed without prejudice. We're off the record.
Sunday afternoons. WRCJ, Detroit, Windsor, and Anna. All classical jazz music station. Tell your smart speaker play WRCJ. Get that free app. It's free. Go to the app store. Angelo Corelli, composer of many works, titled Concerto, especially the 6 works of his. It's meant a collection of 6 works. One of a trio of works celebrating nature, life, and love. So, overtures. Nature's been fun and fun in the middle. That's it. Second. 16 string quartets from Beethoven. Surprise ending. Quartet for moment. Johann Sebastian Bach. The overture by Peter Tchaikovsky. That's our next hour of music. Stick around. Be a lot of fun. With good music. Relative temperatures this week. Very good. That is a little bit warmer in Michigan. Low 90s to near. Third week of July. This time of year. Jean Bear as a French Navy officer here on ship cruising throughout the Mediterranean. Made stops in Tunis and Valencia, Spain. Opening stops. Scott, Forts of Call, Jean Bear, there's some of his musical experiences.
Good morning.
Morning, Your Honor.
Morning, Your Honor.
This is 22-178-196, Henry Ford Health System versus Hanover Insurance. Date and time for pretrial, your appearances.
Paul Mullenbach, P 42795 on behalf of the plaintiff Henry Ford Health System.
And Joy Glovic, P6691 on behalf of defendant Hanover.
Okay, so our disclosures have been made. Where are we on the file?
Your Honor, we've had several settlement discussions. I don't think we're in dispute as to the fact that the bills are owed. It's just right now it's kind of an accounting. Some bills have been paid. I've gone back to the defense attorney and she's found that some bills were paid that shouldn't have been paid. And so I just got some notice of that last week and I've sent that over to my client and we're just trying to sort it out. Right now, it's a little bit of an accounting nightmare. But hopefully I've sent it over to my client and hopefully between the two of us, we can figure out what's going on and get this thing resolved. I think I'm 100% confident we'll resolve it. It's just a matter of figuring out what's been paid and where and credited to what.
Always a problem. And I take it you have automated accounting systems?
Well, that's part of the problem that happened is that there was a payment that was forwarded directly to Mr. Millenbach from my client. And then there's others that were erroneously forwarded directly to Henry Ford. So actually at this point, Hanover has basically overpaid on all but maybe $35. So,
Joy.
so the fun and games that we have, and unfortunately, I know from prior experience dealing with other hospitals and other cases that sometimes tracking down those payments is a problem. I have forwarded to Mr. Billenbach the cash check to help make that a little bit easier. But yeah, it's
my wife and I have the same dentist. We go on different schedules, and she still can't get the billings right. So what can I say? How about we have you guys back August 29th at 11? Does that work for everybody?
That should be fine with me, Your Honor.
Let me double check. I just want to make sure. I think that's okay. Yep, I'm perfectly okay that day, so that'll work.
August 29th at 11 o'clock. And hopefully we can get this thing resolved.
Yes, I hope. Hopefully.
Thanks for coming in.
Thank you, Your Honor.
All right, let's be
See you
safe
later.
out there. Have a great day.
You too.
Thank you. August 29th. Okay, we are on the record. This is 21-167-134. Beaumont Health versus Monique Patterson. Date and time for pretrial. Your appearances.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Ms. Patterson?
Monique Patterson.
Okay. Where are we on this file, people?
I'm sorry.
Your Honor, if I could begin and then Ms. Patterson can critique this. The last time we were here, I believe, and actually the time before, we discussed a consent judgment. She was going to pay $100 a month beginning June 22nd. We emailed her a consent to review and sign, and we have not gotten it back. At another time, she offered 75% in the lump sum plus court costs, both of which we can take. And now I'll defer to Ms. Patterson. I want to resolve the case, and I'm open to either one of her offers.
Ms. Patterson, what's going on?
Well, I worked with, it's called avo.com, and I finally got referred to an attorney that's willing to take the case. However, I just received his paperwork this morning for me to sign, for him to get the information that he need on the case. His name is Dan Randazzo.
Well, you can't file an appearance for him. So
No, he couldn't.
what I understand is you're not ready to resolve the matter. So I'm going to just give you guys another date. And if he's going to get in the file, Ms. Patterson, have him file the appearance. The appearance is a document by which the attorney says he or she is in the case.
Yes, he said I had to sign the documents first before he can become attorney, and I just received it this morning, Your Honor.
All right, August 29th. Does that work for everybody at 11 o'clock?
It does for me, Your Honor.
Okay, August 29th at 11 o'clock will be our next time. And
Okay.
we will be proceeding with this new lawyer, or we will be proceeding without him. But if he doesn't file the appearance, he's not in the case. In the meantime, we can get started on our written discovery because we're not resolving the file.
Okay, well, I'm going to sign the paperwork today, and then he said, I guess he's going to put in his appearance, and also he needed the documentation from that they filed, and he said that when I came down there with the answer, and I did give him the other information that I had.
All right, thank you. August 29th at 11 o'clock. We need
Thank you,
to
Your
start
Honor.
on our discovery. We're now 60 days in this case. We need to get
Yes,
through
we
the
are.
new written discovery. We need to do it.
Okay, hopefully he's able to
29th.
do everything today as soon as I sign it.
August 29th, 11 o'clock.
Okay,
Thank
thank
you. We're
Thank
off the record. We'll send you out a notice.
you.
We are on the record. This is 21-172-132 LVNV funding versus Quinta Gaines. By a notice dated June 13th, 2022, this matter is set for a motion for summary disposition today, July the 11th at 11 o'clock. Could I have your appearance?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you today?
Good, sir. How about yourself?
Not too bad.
Mr. Kirschenheiter, did you get an answer to your motion for summary disposition from?
We did not, Your Honor. This was actually resolved. Ms. Gaines made a settlement payment and we're closing out our file, but she never sent back the dismissal. So at this time, I'm just asking if the court will dismiss the case. That works for me.
What do you want me to do? Dismiss it with or without prejudice?
I would prefer without, just in case the payment bounces. I don't suspect it will, but without would be best.
The matter will be dismissed without prejudice on request of counsel for the plaintiff.
Thanks a lot, Judge. Have a great day.
And let's be safe.
Yep, take care.